So he says, this says, if a resolution plan is ex facie not in conformity with the law and of the provisions, because it says it should conform to the required. Section 30 subsection 2 says that it should be in conformity with the provisions of law. There should not be any contravention of any law. And now this was contravening the law because statutory dues were there. There was litigation going on. So RP was very much aware. He did not even include it in information memorandum. So if it says that if a resolution plan is ex facie not in conformity with law and or provisions of the code and or the rules and regulations, the resolution plan would have to be rejected. It is also a well settled principle of interpretation that the expression may, if the circumstances so demand can be construed as shall. If the resolution plan ignores the statutory demands, this is the logic basically. If it ignores the statutory demands payable to any state government or a legal authority, altogether the A is bound to reject the resolution plan. What if plan proposed 0.1 or 2%, whether it means it considers demands or not? If the resolution plan ignores the statutory demands payable to any state government or legal authority, altogether the adjudicating authority is bound to reject the resolution plan. If a company is unable to pay its debts, which should include its statutory dues to the government and other authorities, and there is no plan which contemplates dissipation of those debts in a phased manner, uniform proportional reduction, the company would necessarily have to be liquidated and its assets sold and distributed in the manner stipulated in section 53 of the code. So the committee of creditors, which might include financial institutions and other financial creditors, cannot secure their own dues at the cost of statutory dues owed to any government or governmental authority, or for that matter, any other dues. So this was the logic basically. Because this will defeat the objectives of IBC. Uniform proportional reduction in case there is statutory dues. If not, plan should be rejected and company should be liquidated. Then commercial wisdom of COC. Any other dues, whether it means COC cannot secure its dues at the cost of operational creditors also. Then overriding of IBC over section 48. This was also the issue. So it says that section 48 of the GVAT Act is not contrary to or inconsistent with section 53 or any other provision of the code. Under section 53 1B2, the debts owed to a secured creditor, which would include the state under the GVAT Act, are to rank equally with other specified debts, including debts on account of workmen dues. So the delay in filing cannot be the sole ground for rejecting the claim, and state is a secured creditor under GVAT Act. So section 3 subsection 30 of the IBC defines a secured creditor to mean a creditor in favor of whom security interest is created. Such security interest could be created by operation of law. So the definition of secured creditor in the IBC does not exclude any government or governmental authority. So section 48 of the GVAT Act, notwithstanding anything to the contrary, contain any amount payable by a dealer on account of tax interest for which he is liable shall be a first charge on the property of such dealer. So this was the judgment basically.